Good night, everyone. This is U.S. Immigration Attorney Sharifa Tharpe, and I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. So tonight, I usually come every night, actually, I come here at 9 o'clock, 9 p.m. Eastern Time to take your questions, and tonight is no different. So go ahead. Start putting your questions in the comments so that I may answer your U.S. immigration related questions. Let me formally introduce myself. For those of you who don't know me, I'm U.S. Immigration Attorney Sharifa Tharpe. I help clients to get their status and green cards in the United States. And so one of the things you can ask me are questions related to that. I mean, you can ask me anything that's immigration related, but feel free to also ask me about the green card process and any general questions you may have. If you would like to schedule a consultation, or if you want to learn more about me as the U.S. immigration attorney, you can go to the link in my bio. It will take you to the website where you can you'll find the contact information, the contact form that you can complete to get in touch with me, the scheduling coordinator, who will then schedule your consultation. So now, while I'm here, you can go ahead and put your questions in the comments. I usually come with a topic to talk about, and tonight I'm going to be talking about applying for adjustment of status or even consular processing when you have an issue that may render you inadmissible. So I'm going to talk about one way that you can solve that problem if you have been found inadmissible. Many individuals have the misconception that if they are found inadmissible, there is no hope. However, you should definitely schedule a consultation to understand your situation and understand whether you have options. So there are waivers that are available. So whether you have been deported and you're currently outside of the United States, or you've been convicted for a specific crime, or you've had a past immigration violation, then there may be waivers available to fix the situation and still allow you to come back to the United States and get your permanent residence. Of course, you do have to have, for most of these waivers, you do have to have a qualifying U.S. citizen or resident relative to be able to qualify for the waiver. Now, there are some violations, some criminal violations, some immigration violations that there are no waivers available, and unfortunately, you usually coming back to the U.S. is going to be an uphill battle, and at sometimes impossible. However, it is important to understand when you do have options to get back to the United States, to be able to get with your family members. So in certain cases, so there are certain instances where you may be found inadmissible. If you have criminal issues, so for example, if you have been convicted for 2 or more crimes that have a total sentence of 5 years or more, that would render you inadmissible. If you have a crime involving moral turpitude, and a crime involving moral turpitude is kind of like a catch-all type of provision, because it involves criminal activities that are maybe reprehensible. However, there is no specific definition of crime involving moral turpitude. One of the most common, maybe close to definition I've seen, are where the acts are so depraved that it definitely leads one to conclude that it's a crime involving moral turpitude. Now, examples of crimes involving moral turpitude could be fraud. It could be anything where there's a victim involved, if someone got hurt. So for example, assault, sexual assault. For example, in New York, forcible touching can be considered a crime involving moral turpitude. At times, it is a complex determining whether your crime involves moral turpitude. For example, in some states, maybe shoplifting may be considered a crime involving moral turpitude. I mean, it really comes down to the state law, so where you were convicted, what state, and then, believe it or not, the statute, whether there was intent, what were the facts related to your situation. And if it falls under a crime involving moral turpitude, you would be found inadmissible. And this goes for crimes that happen in the U.S. as well as outside of the U.S. Should I get married with my girlfriend? She's a USA resident. So that is a question that I would have to speak with you in a consultation. I wouldn't be able to tell you in particular whether you can marry your girlfriend. However, what I can tell you is that the spouse of a U.S. citizen or legal permanent resident does qualify for the green card. So spouses of U.S. citizens or legal permanent residents qualify for permanent residence. However, the way that you're going to go about it depends on where you are. If you're in the U.S., what's your status? If you're outside of the U.S., you'd want to know how long. I mean, in that case, it's a smoother process. It's a more straightforward process, but you're going to have to go through the consular processing, meaning you are going to have to go to the embassy. But if you're here in the U.S., you're out of status and you're married to a resident, U.S. resident, not a citizen, then that may involve applying for a waiver. If you are the spouse of a U.S. citizen and you came in with a visa, then that may be adjustment of status. So my specific advice to you is going to really depend on your particular circumstances, and that's where it's very important to get a legal consultation. The information here I'm giving you and I'm giving everyone is not personal legal advice, it is general information. And so if you would like me to tell you how it will affect your immigration process if you marry your girlfriend, I can definitely do that in a consultation. So Tasana, the cost of the consultation is $150 for up to an hour. Now, I always like to follow that with it is worth it, because you walk into the consultation not necessarily knowing what you qualify for, or you're not certain of your situation. When you walk out of this consultation, you will know your options. You will know how to approach your situation. You will know whether you are avoiding a mistake. You'll avoid mistakes, and most importantly, you could avoid devastating, very expensive mistakes in the future. So it's very important and it's worth it to get a consultation. Go ahead, keep putting your questions in the comments. I am here to answer your U.S. immigration related questions. So why not take advantage of a U.S. immigration attorney being here right now in front of you to take your questions? So I have come with a topic to talk about, and I'm talking about that very complex topic of inadmissibility and how you can still obtain permanent residence even if you've been found inadmissible. So I'm out of the USA, have no visa. Can you tell me what's the best way to make it happen? So you'll have to apply for a visa. If you qualify through a family member, maybe that is one way. For example, you say you have a resident girlfriend. That could, and that if you two are serious, you are ready to make that take that next step and get married, then that could be your path to the USA. However, I wouldn't be able to tell you specifically what to do until we do our consultation. However, if you just want to visit temporarily, a visitor's visa may be the right start for you. Keep those questions coming. I'm here to answer your U.S. immigration related questions. So put those questions in the comments. Don't hesitate because I am talking. Just go ahead, put those questions in. You're welcome, your favorite one. just go ahead, put those questions in the comments. Now, your question does not have to be related to my topic. It can be anything that's immigration related. Now, if you are, I was just talking about different types of crimes that can cause you to be inadmissible. When I say inadmissible, when someone is inadmissible, they're not allowed to enter the United States or to get the permanent resident. But there may be ways to get around that through waivers. You usually have to have a qualifying relative to apply for this waiver. Now, the waiver is really, whether you qualify for it, it's really going to be dependent on the facts in your particular case. It's going to be dependent on who your qualifying relatives are. So, for example, if you have a U.S. citizen sibling, that may not work for to get a waiver, because usually the waivers, we usually refer to it as the extreme hardship waiver or the I-601 waiver. Those would usually be based on the extreme hardships of your U.S. citizen or legal permanent resident spouse or parent. In some types of waivers, it may even be dependent on the extreme hardships of your U.S. citizen child. However, if, for example, if you got deported because you were here without status and you accrued unlawful presence, then the unlawful presence waiver through the I-601 waiver would qualify you if you're outside of the U.S. If you're in the U.S. and you know that you've overstayed your visa, you're going to be inadmissible, and so you can apply for the provisional unlawful presence waiver. So and if you have a certain crime, now there are certain crimes, so for example, they're called aggravated felonies, that they have a permanent bar and there's no waiver available. Now, you would be shocked to see some of these crimes on the list. So, for example, hi there, Poor Man NYC. Hello, I applied for a 10-year green card for my wife. After 1.5 years, and then I didn't see the rest. I'm from Guyana. I got interview letter, but we have no joint account. So, Poor Man NYC, I don't know what are the other pieces of evidence that you have. I don't know what your situation is, and this is where it's best to get advice, especially if you've already done the interview and they've either sent you a notice of intent to deny, or they have straight up asked you for these documents. It's very important for you to get a consultation to see how you can approach a situation. Now, not everyone's circumstances are different, and not everyone is going to have a joint bank account. And so while I can't advise you specifically whether this absence of the joint bank account is going to be detrimental to your application, I can tell you that it usually it's not, as long as you have other strong evidence. So you raise the fact that you have tax returns. And if you file joint tax returns consistently, then definitely that is strong evidence. And if you have a daughter, if the both of you are the biological parents of your daughter, that is definitely strong evidence that you have a bona fide marriage. So, while I can't confirm whether everything will be okay, because I don't know all your circumstances, and I'm not your attorney, I'm not working on your case, having a child together within your marriage, having joint tax returns can definitely make up for not having joint bank account. I'm married with 2 kids and I'm working in a government job. I would like to apply for a visitor's visa. So definitely you are free to apply for the visa. What I can tell you, when you're applying for a visitor's visa, it's very important to show that you have strong ties to your home country. And so you're married, you have 2 kids who are in your country, and you have a good job. Especially if it's a long-standing job, those can definitely be a positive when applying for the visa. Make sure to show these things, these strong ties in your application, And if you have other types of strong ties, such as property, maybe a side hustle, those can also count. What is the current processing date for the F4? So I don't know which country you're in, but right now the minimum time it's taking, and the F4 category where the U.S. citizen sibling who's 21 and up, they're sponsoring their sibling. Malaysia, you're welcome. And so it's taking a minimum of 14 years, for example, in the Caribbean, but in Mexico, it's taking upwards of 20 years. So I know it's impossibly long, and maybe something will change in the future, but right now it's a 14-year process. So it's not a quick and easy solution to get permanent residence. But if it's your only way, the only way that you qualify, then definitely it wouldn't hurt to apply and then wait it out. Keep those questions coming. So far, these have been great questions, and these are the exact type of questions I want to get. So go ahead, put your questions in the comments so that I may continue to answer your questions. Now, I also want to let you know that if you're here, you're listening, you can always tune in to listen to what I have to say. Every night at 9 p.m., I will be here with very few exceptions, of course. And when you're here, you still have a whole hour to sit in on a live show with me, because because once at 9:30 I will be heading over to Instagram, where I do another half an hour live show. So if I didn't get to your questions here, I can always do it on Instagram. I also release my videos there. So many of my videos are now on Instagram, where they're more informative, and so it would be a good place to be if you want to get updates every day. Instagram would be the place to get that information. However, if you want to join me on live on TikTok every night at 9 p.m., you can do that as well. So many different options to follow me, get information, get answers to your questions. You're welcome, SS5920. Hi there, Queen just said, it's nice to see you. Now, if you would like to go to my Instagram page, it is, if you go to the link in my bio and then you click on the Instagram button, you can head over to Instagram, where I definitely publish more valuable content, short videos, but value-filled content, as well as do lives. Now, if you want to continue this conversation at 9:30, it doesn't have to end here. All you have to do is go over to Instagram and continue the conversation with me. But I am still here, and I'm still here until 9:30 p.m. So go ahead and keep putting your questions in the comments. I've also been covering a topic that is very complicated, and I'm giving you general information about it just to let you know that it could possibly be an option for you. And that's if you are inadmissible. So when I say inadmissible, do you have something in your background that you have a feeling or you're afraid is going to affect your ability to get the green card? If so, then if you do have a concern like that, you definitely want to make sure that it's not going to render you inadmissible. But even if you're inadmissible means you're not allowed to get the green card or enter the U.S. or be in the U.S. So if you're inadmissible, there are ways to get forgiveness for whatever caused the inadmissibility and then move on to get permanent residence anyway. Of course, there are some types of immigration violations or criminal violations that can never get a waiver. But it's so fact-based that you definitely would want to get a consultation to determine whether what happened in your particular case can still qualify for a waiver. And also, it's really dependent on, hi J Hind 274, on whether you have a qualifying relative. Now, a qualifying relative, some of these waivers depend on how your absence or your bar from getting the green card will affect a qualifying relative such as a U.S. citizen or legal permanent resident, spouse, or parent. Now, if, for example, you have had a criminal violation, I am good, Jayhine. Thanks so much for asking. I hope you're doing well as well. Now, if you have, for example, a criminal violation, and that criminal violation allows you to get a waiver, there are two ways to do this. So if more than 15 years has passed, and you have been rehabilitated, then that could be one way. You don't need a qualifying relative for that waiver, as long as more than 15 years has passed since the crime happened. However, if it's still been less than 15 years, you'll need to have a qualifying relative, such as a U.S. citizen or legal permanent resident, spouse, or parent, who will experience extreme hardship without you. Jayhine274, thanks for sharing the live. One thing I do want to add as well, though, is that if it's a particularly dangerous or violent crime, a waiver still may be applicable. However, you're going to have to show that your relative, your qualifying relative, will experience exceptional and extremely unusual hardship. So that means even more severe. They will experience even more severe hardships than extreme hardship. And so it's very important to get a consultation, because if you thought coming back to the US was impossible, I want you to know that these options are there for you, and if you qualify, you could pursue it. Also, if you got deported because you were here unlawfully, you don't have any criminal issues, you don't have any other problems going on, it was just that you did get caught, you got held, and you got deported, there are still ways to come back to the U.S. with the unlawful presence waiver. If you're outside of the United States, then it's going to be the I-601 waiver, and that's going to be dependent on the extreme hardships of your U.S. citizen or legal permanent resident, spouse, or parent. Now, also keep in mind that there's also additional factor. If you're outside of the United States, and say you must stay outside of the United States for 20 years, then you'll also have to apply for what's called permission to reapply for re-entry along with a waiver. Of course, these are things that I do help my clients to do, and so what you will need to do is schedule a consultation to determine whether you qualify to apply for this, to see if you can get forgiveness and come back to the United States. Or even if you're in the United States, I also want to mention that because these waivers can apply even if you are here in the United States. So if you, for example, qualify to stay in the United States and apply, but you have this issue. So say you were charged with misrepresentation or fraud, immigration misrepresentation or fraud, then, and you qualify to apply for permanent residence in the United States, you could submit the waiver application here in the United States, as long as you do have that qualifying relative, such as a U.S. citizen or legal permanent resident, spouse, or parent. So it's complex stuff, but that's what I'm here to do, is help you to figure it out and help guide you through the process, represent you through the process, advocate for you during the process. You just have to take the step to seek legal advice and schedule that consultation. There is a scheduling coordinator who is available up until 11 p.m. Monday to Friday, and then also Saturdays, Sundays, noon to 5 p.m. You can start making your calls to schedule if you want to immediately schedule your consultation between 9:30 and 11 p.m. However, keep in mind, phone lines are open 24/7, and so an after-hours receptionist will still take your call, take good care of you still, and then the scheduling coordinator will get back to you on the next business day. So my spouse is a U.S. citizen and I have a visa. I want to get my son the visa, should I? And so You can always apply for, I think you're talking about a visitor's visa. However, whether or not you get it is really going to depend on whether you can show the officer that you qualify. When it comes down to the visitor's visa, you do have to show that you have strong ties to your home country to return if after a temporary visit to the United States. So while I can't advise you, it's really a decision you have to make about whether you want to pursue the visa. There's nothing that can stop you necessarily legally. I don't know what your situation is, but generally there's nothing that should be stopping you from applying for a visitor's visa. You're always free to apply for a visitor's visa. However, keep in mind that you do have to show that you qualify for it. Will91, thanks for sharing the live. I appreciate that. So let's see. I think I skipped some questions, so let me go ahead. Is it best to let my in-law or my brother be a petition for me? So Will91, I'm glad that you asked this question. Now, in-laws cannot directly petition for you. Where you may be able to get a permanent residence through your in-law is if you have a U.S. citizen in-law, like parent-in-law, mother-in-law, or a father-in-law who wants to sponsor your spouse, and your spouse. So that in-law wants to sponsor their own child, which is your spouse. In that case like that, you would be able to go along with that spouse, your spouse. However, the in-law isn't directly applying for you. You are called a derivative, meaning you're the person that's added to the application. And so you would have to, first of all, does your spouse qualify for the permanent residence? And usually to qualify, at minimum, they'll have to have U.S. citizen parents to qualify. Now, your brother could petition for you if they're a U.S. citizen. Now, if you went through your in-law who is a U.S. citizen, right now that process is taking 12 years. If you are going through your brother, then that's taking a minimum of 14 years, and it depends on where you are. Right now, the minimum time is 14 years in the Caribbean, like Jamaica, for example. In Mexico, it's upwards of 20 years. Okay, and Will91, and can I stay in the country while being petitioned for? So not through your in-laws and not through your brother. The reason being, if you don't qualify to apply for permanent residence, if you fall out of status. So if you don't have a visa or your visa expires while you're in the United States, and when I say expire, I don't mean the 10 years. So if you get a 10-year visa, it doesn't mean when you come to the U.S., it doesn't mean that you can stay the 10 years in the U.S. on that visitor's visa. It just means that you don't have to go back to the embassy to renew it for another 10 years. But what you have to look at is the date that the officer at the airport or the border gave you, the amount of time they gave you to stay, that they stamped in your passport or they put on your I-94 for you to stay. Once that time passes, you will fall out of status. And if you are not the immediate relative of a U.S. citizen, that means if you're not the spouse of a U.S. citizen, if you're not the parent of a U.S. citizen who's 21 and up, or you're not the son or daughter of a U.S. citizen who is under 21 and unmarried, you're not going to qualify to apply for permanent residence in the United States. And here it doesn't seem like you fall within that category. And so my short answer to you is no. If you're already here and you've overstayed, then you will likely have to have a U.S. citizen or legal permanent resident spouse or parent who will experience extreme hardships without you, which in this case, you don't have. So the short answer is no, you would not be able to qualify to stay in the U.S. However, it's general information I'm giving you based on the very general information that you're giving me. If you would like to make sure that you qualify, or make sure that there is no option, there are no other options for you, schedule a consultation. Let's talk about your particular situation. Let's talk about your facts so I can provide those answers. Can you please tell me, after approval in VAWA, how long the green card will take? Get 2 years or the 10 years? So you will likely get the 10 year. So you're going to get the 10-year green card. However, I at this point, I don't know when. I know overall you could expect a 2-year process. However, I don't know when you'll get approval, and so it's hard for me to determine when you would get through with the interview and all of that. I am from the Caribbean but would like to migrate. So definitely that's a broad question. It really depends on how you qualify. So I'm out of the US over a year now. I'm heading back next month. Will this have any problems? Latamia, it could possibly cause problems for you at the border. Definitely get in touch with me, schedule a consultation. At times when you're outside of the US for over a year, you usually have to apply, because it's assumed that you have abandoned your permanent residence, and so you usually have to apply for what's called an SB1 visa, immigrant returning resident visa, at the embassy before coming, and that should help you to get into the US without any complications. But schedule a consultation and let's talk more about this. Now, my time is up, and here I am going over to Instagram. So this conversation does not have to end here. All you have to do is go to the link in my bio, click the Instagram button, and you can join me in a minute on Instagram. I do have a pre-scheduled live at 9:30 there. So we don't have to end the conversation there. Stawil91, you're welcome. So if you would like to schedule a consultation, go to the link in my bio, go to the website. There you'll see the phone number, and scheduling coordinators available up until 11 p.m. But the number is 24/7, where they'll take good care of you, and a scheduling coordinator will get back to you on the next business day to schedule your appointment. However, if you want to continue to ask questions, I didn't get to your question, hop on over to Instagram. Let's continue this conversation over there. Have a good night, everyone. I'll see you tomorrow. If you can't make it on Instagram, I'll see you tomorrow at 9 p.m. Have a good one, everyone.